2020. Apologies for the slow start at the beginning of the year. So we're getting used to the procedures again. We're very happy to start a presentation by someone who has been around over the summer with us, Chloe Romanis. So she was a visiting researcher here over the summer, and we thought before she leaves back for Manchester that we could pick her brain and have her present some of her research at the seminar series here. This is why we start so early. Normally we have a slower start. We start a week later or 2 weeks later with the seminar series. So we're very happy to have Chloe Romanis. Before I say something more about her, I want to distribute already the attendance list, which students who take the seminar as a course should definitely fill out. But I would also ask the other people to simply indicate who they are or their affiliation. It gives us an idea of who we reach as an audience. And if you're not familiar with the seminar series and your email address is not on the list, you can add that actually so that you are alerted about the new events that we organize. I'm also distributing here the list for the fall seminars, which the next seminar is actually already on September 27th, so you can have an idea of what we will be doing in the fall session, and there may be some other events that will be organized in the fall, but definitely also then going into the new year. So without further ado, let me briefly introduce Chloe Romanis. She's a final year PhD student funded by the Wellcome Trust. She's finishing her degree in bioethics and medical jurisprudence at the Department of Law at the University of Winchester, and she's connected to the Center for Social Ethics and Policy. Some of her recent publications include, for example, Artificial Womb Technology and the Significance of Birth, Why Gestatelings Are Not Newborns or Fetuses, which is published in the Journal of Medical Ethics, and many other publications, so keep an eye out for her publications. We're very happy to have also Professor Werner Dickens as commentator, who doesn't need an introduction, certainly not in this setting, but even internationally. He's known as the father, one of the fathers of health law and bioethics in Canada for sure. He's a professor emeritus of health law and policy and the co-director of the International Reproductive and Sexual Health Law Program, with cross appointments in medicine, public health, and the Joint Center for Bioethics. Just to mention some of the relevant expertise, he's a member of the Committee on the Ethical Aspects of Human Reproduction and Women's Health, the International Federation of Gynecology and Obstetrics. He was also chairman, actually, of this committee for several years. He's a fellow of the Royal Society of Canada and the officer of the Order of Canada. And recent publications include the co-edited book, Reproductive Health and Human Rights, Integrating Medicine, Ethics and Law, which was co-edited with Rebecca Cook and Mahmoud Fatala, translated in French, Spanish, Portuguese, Arabic, and Chinese. So without further ado, I will Chloe start, and then we will open up for questions. I have received questions from students, so we will start with some of the questions of the students, and then we take it up with the general audience after the commentator. Okay, thank you.
Thanks so much, and thank you so much for hosting me over the summer. I've had an amazing time, and Toronto is such a wonderful place to spend the summer, so thanks so much. What I'm presenting today, I think lots of you might have read the paper already, but this is what I envisage will be paper 6 in a series that makes up my PhD. So all of the questions are kind of interconnected, and it looks kind of awful. I reference myself quite a bit. I promise I'm not like that arrogant and do that all the time. It's just because everything fits together into a PhD. So how I came to this was I noticed a recurring speculation in both the bioethical and the legal literature that artificial wombs were going to solve like a myriad of problems. So I was also guilty of this by claiming that they were going to solve all the problems associated with being born premature. But there were also lots of feminist authors in a wide variety of disciplines claiming that all of the burdens placed exclusively on women in reproduction would only be solved at the point at which we had machines that were capable of taking gestation exclusively away from a female body. Throughout this paper, I am going to refer to people who experience pregnancy as women. I am aware that lots of people experience pregnancy without identifying as female, but I think that because this paper is about choice and the way in which women have access to choice, a lot of the reasons why some choices are more limited or presented as limited are because they are accessed by a population that is a majority women. So because of these recurring claims, I thought to myself, okay, well, why is it that people think that these burdens are alleviated by an alternative to gestation? What kinds of choices are we actually looking at, and will they be made available by the existence of this kind of technology? No one had really provided an account of that before. And secondly, even if we could envisage this technology, and even if it became possible, it didn't really seem useful to me as a choice unless it was legally accessible. So I wanted to look at the framework of ending pregnancy in English and Welsh law. Sorry, this is going to be really English-centric. I'll try and relate it to Canadian law if I can. But I wanted to know how accessible those choices would actually be in the law. So just a brief introduction first to the technology I'm talking about. So artificial wombs are essentially machines designed to facilitate what's known as ectogenesis. That's the process of gestation ex utero. And there are currently 2, and I think about to be a third, working teams developing this technology and currently testing on animals. And they exclusively are working on the technology as an alternative to neonatal intensive care. So they're aiming at being able to sustain fetuses at around 23 to 24 weeks born premature, as opposed to, as has also been theorized, creating machines that would be capable of turning an embryo into what we know as a newborn baby. And proof of principle for the technology has been claimed by these 2 research teams. So the first, the BioBag, is based out of the University of Pennsylvania, and the second, the Eve platform, the University of Western Australia. And this design here, this is the first image to come out of the BioBag study. It demonstrates exactly how this technology is designed to work. So it's attempting to mimic the function of the human uterus, and as Bernard helpfully pointed out to me yesterday as well, the placenta. So it's a sealed bag of amniotic fluid. It has a pumpless oxygenator circuit, which is designed to minimize the stress on a fetal heart, and umbilical cord access through here that provides like all of the nutrients and stuff you would expect exactly as a pregnancy, effectively from a functional sort of artificial placenta. There are 2 important features of this technology, at least I hope so, otherwise I don't have a PhD. So I've claimed that it's conceptually distinct from other forms of assistance technology that we already have, like neonatal intensive care, for a few reasons, and I'm just mentioning 2 here. The first is a shifting viability timeline. I've put a question mark here because in terms of the technicalities of how the law works, I am currently trying to argue that there are 2 conceptions of viability we could adopt. And if I am right about that, technically I wouldn't want something in this bag to be considered a viable, well, it would be viable when it's born, but given that it's not born in that technology, I don't think that we would describe younger fetuses as viable. But the argument here, or the thing I'm just trying to point out, is just that this technology is not subject to the same natural limitations that the machines we already use to support preterm neonates are. So at the moment, all of the technology we currently have, like ventilators, cannot support a fetus born before about 22 weeks because they just don't have solid lungs. And if you don't have solid lungs, you can't take in oxygen. This technology wouldn't have those sorts of natural capacity requirements, and so we would be able to use it on younger and younger preterms. The second thing is that it's a distinct subject, so something in a biobag would be not a fetus and not a neonate. The reason being that it's not a fetus in the traditional sense because it's not dependent on a human gestator, and it's also not a neonate because it's not exercising any capacity for independent life and remains in the process of gestation. So I've called it the Gestate name, and I kind of hope it catches on. But the important thing is there are these differences. This technology is currently being researched, and in 4 recent publications, these teams have claimed that they are almost ready to start thinking about testing on human subjects and have identified potential clinical populations. So it is significant. I see this technology, therefore, as a potential replacement for neonatal intensive care. There are some limitations to that claim. Firstly, that the technology just isn't ready yet. Like, there are limitations to these studies, things like short sample sizes, lambs at preterm viability about 3 times the size of human neonates, so you'd have to do a lot to make the technology work, and that will take time. Moreover, there are some quite intricate ethico-legal issues embroiled in potentially testing the technology. So all of the potential implications of it, I think, are quite far in the future. So for the purposes of this paper, I'm going to make a very big assumption that this technology is available and is considered safe for use in human beings, to the extent that we would be able to explore some of the implications of the potential widespread use of the technology. Given I've just spent a while telling you that it's not really going to be around for a bit, I still think that the questions are useful to ask. Firstly, because I think when you look at really nuanced ethical and legal questions, sometimes you need lots of time to think about it and think about all of the random obscure arguments before you get into the practicalities. That's why I think this is important. But also, I found this exercise to be a really useful legal imaginary in terms of approaching the Abortion Act in England with a very critical perspective and actually looking at the meanings of words that I wouldn't have bothered to look at were it not for thinking about things in a very futuristic sense. So, there are 2 potential new choices then that could come out of this technology if it's safe and widely used. The first, and this is the most common one that I normally get asked about, and also that philosophers love to talk about, is this idea that if there's an alternative form of gestation, this should potentially be the end of abortion. If there's an alternative form of gestation, all women must be forced to make a choice between ending their pregnancy in such a way that results in fetal death, or by effectively, before birth adoption, allowing an artificial womb to sort of take over. And the second one is, the one I'm more interested in, and I'll explain why in a minute, is that for women who do actually want to become social mothers, they would like a child, but they think that the burdens imposed by pregnancy and that experience are too much or too risky for whatever reason, and so they would like to choose an alternative to that rearing before birth. So, I'm going to quickly dispel this because it's a bugbear of mine when people talk about artificial wombs as an alternative to abortion. I have to say my account of this is very much influenced by my work with a colleague, Claire Horn, who's amazing. Her PhD is on something very similar to mine, so we have a hopefully forthcoming article and book chapter together explaining exactly why it is that we don't think artificial wombs are an alternative to abortion. As you can see here, and this is only a select few, the vast majority of scholarship on this subject is focused on this question of, well, should we restrict abortion? Should we ban abortion? Okay, 4 reasons. Firstly, fetal extraction for ex utero gestation, so the process of removing a fetus to put it in an artificial womb, is just not in any way comparable to an abortion. These days, the risks associated with even surgical abortion, but also drug-induced abortion, are so much less than the really intricate process that would require fetal transfer. So we're talking a caesarean section, but not just a caesarean section, a very intricate one that does things like preserve blood vessels in a particular way so that they would be able to be sustained in the artificial womb, the fetus I mean. At which point, I think that's not a comparable choice to make a woman make, right? So having an abortion, opting for fetal transfer, just not comparable in terms of experience. The second is timing of access, right? So at the moment in England and Wales, 97% of abortions take place before 13 weeks. There is no evidence that this technology would be able to sustain, and at that point, an embryonic product of conception that's like young in the process, right? So essentially, we might be forcing women to remain pregnant for such a period of time that they would then have to opt for this technology as an alternative. And any period of forced pregnancy, I think, is wrong. Thirdly, I think it fundamentally misunderstands why abortion is provided or protected in liberal progressive societies. Access to abortion is a form of healthcare that is not just necessarily about the freedom from pregnancy, like philosophers like to talk about it, but it's about so much more. It's about access to a right of sexual equality, it's about access to a choice not to become a mother, it's about so much more. And there's a wealth of literature on that I don't have time to explore, but it's very interesting and important. And finally, and this is something we're having real trouble getting published because people don't like it, we argue that philosophers and lawyers making this argument actually do a lot of damage by creating a really problematic narrative and rhetoric around abortion. If you claim that we should ban abortion or abortion is a problem when artificial wombs exist, you effectively problematize contemporary provision, which is already quite precarious in the United States and in some parts of England, by claiming that abortion is a problem that will be solved by technology. It's just that we're not capable of doing that yet. And we think that's symbolically quite a horrible claim to be making and quite problematic in terms of rhetoric. So that's the reason why artificial wombs are not an alternative to abortion. So I frame that out as a choice that I think is happening. What I think is really important is artificial wombs as an alternative to full pregnancy. So in those circumstances that a woman, for whatever reason, does not want to carry a pregnancy for 37 weeks, but would like the product of pregnancy to survive, or would like to become a mother, this offers an alternative. The decision to deliver the product of a pregnancy preterm, so before 37 weeks, is actually already really common. We see it all the time in obstetric practice for a wide variety of complications. Things like preeclampsia, or stress and trauma, or other forms of pregnancy complications like diabetes. There are two decisions that obstetricians make in that process when they're trying to decide if they should end the pregnancy. The first would be whether or not to end it. So what is currently happening in terms of the pregnant woman's experience, how dangerous it is, do we need to end the pregnancy? And secondly, how do they end that pregnancy? And there are a variety of factors that they would balance in trying to make those two choices simultaneously. So the first might be the gestational age of the fetus. So already guidelines say that you shouldn't really attempt to resuscitate a fetus before 22 weeks if it's born premature, because it just wouldn't be functionally mature enough to survive. So if a woman is experiencing a very dangerous pregnancy at 20 weeks, obviously the decision would be to terminate it by a conventional abortion. So those sorts of questions weigh in. And then there's additional complicating factors like how serious is the complication. Can, for example, if she's anxious to save her child, can we wait 2 weeks so that that gestational age factor isn't so much of a problem? And then if we wait those 2 weeks, what additional risks does that woman face? And what are the risks of the fetus in terms of being born premature and all the risks associated with neonatal intensive care, which is very dangerous, versus remaining in a potentially difficult uterine environment. So all of those things are quite complicated for obstetricians to weigh in, especially when they're looking at quite tragic situations where women really do want to save themselves and their fetus, and they don't necessarily want to have to sacrifice either their life or their fetuses. So I've argued in this paper that I think lots of these factors are potentially framed out by artificial womb technology. The first and most important thing is I think the threshold of sufficient risk to justify ending a pregnancy might be lowered. So at the moment, if a woman's anxious to save her fetus, she might direct her obstetrician to wait as long as possible so that the fetus has a greater chance of survival. If this technology exists and works, you won't have to worry about the same complications with neonatal intensive care or things like gestational age, so a woman can opt to end her pregnancy earlier or at a lower level of risk with less concern. Secondly, I think we can do things like ending pregnancy earlier. So at the moment, if someone has preeclampsia, it's quite a serious complication, but quite often, sometimes, women want to wait as long as possible until it does become very serious, and they have their emergency C-section then. This might allow them to, at the early stages of a complication, opt out of pregnancy. Importantly, I think it could also remove a focus on a comparative account of risk. And I don't think obstetricians necessarily impose this on women. I think this is because women experiencing a wanted pregnancy often also think about it in this way. So they think about the risks they're experiencing versus the risks of their fetus, and they have to weigh it up like that. I think this technology could be a move towards thinking about the burdens and the risks of pregnancy in a way that is exclusively about women's experiences, and that could be really beneficial. And finally, I think eventually, if this technology did work, there might be some people who start thinking about this as an alternative to having a pregnancy on semi-medical or non-medical grounds. So by semi-medical, I mean things like unrelenting nausea that might not necessarily be life-threatening, and by non-medical, I mean things like, I would like a child, just don't want to be pregnant for the full period, for whatever reason. Okay, so in terms of the framework of pregnancy termination in England and Wales, and I found this quite confusing when I first came to it, because I was like, oh, this is effectively a decision about premature delivery, and I don't know whether the legality of premature delivery is that different from the legality of abortion. But the way English law is written, I think effectively it comes under the same parameters still, which is inherently a bit weird. So, the framework of abortion in England and Wales is still that we have the Operating Act as the Offences Against the Person Act 1861. This is 150 years old, and that creates the offence of unlawfully procuring miscarriage. So the actus reus is an attempt to procure miscarriage, and the mens rea is an intent to procure miscarriage. So that's already really broad, and it's made even broader by a requirement. So if a woman does this to herself, attempts to procure a miscarriage, she must be pregnant. But the offence is very specific that if a doctor intervenes to procure a miscarriage, there need not even be a pregnancy. Just an attempt to end a pregnancy is sufficient, even if there isn't one. And then the Abortion Act 1967, as amended, set out some defences to criminal miscarriage that have become to be perceived as quite broad. So there's 4 of them only, and I'm only going to talk about these 3. So the first is where the risk of termination is less than the risk of pregnancy, and we normally call this the social ground of termination, and it operates until 24 weeks. That's the point at which English law assumes a fetus becomes viable. The pregnancy risks her life, or the pregnancy risks grave and permanent damage to her physical or mental health. So those are the basics. So in terms of how this applied to the artificial womb discussion, this changing framework of risk, I kind of had 2 questions. First was, is fetal extraction a miscarriage or an unlawful miscarriage that would need legal justification in order to take place? And secondly, if that was true, would there be a defence, and are any of those defences applicable to allow a woman to make that kind of choice? So, starting with miscarriage, I found this really strange. There was absolutely no definition in the Offence Against the Person Act or any of the amending legislation, so the Abortion Act in 1967 or the amendments to that in 1990. There's been no language superseding the use of the word miscarriage, and yet the use of the word miscarriage appears in no statute since 1861. So it's kind of like it's there but almost abandoned in normal use. All statutes in these areas, so all of these 3 statutes, they are constructed with the not unreasonable assumption that abortion or miscarriage results in fetal death. Because until this technology exists, that's always going to be how ending a pregnancy early sort of works. And the only challenge that has ever been brought to what miscarriage means was Seeman in 2002, but this was about the legality of morning after pill. So it's about whether or not a pregnancy was established to be miscarried if someone took the morning after pill, which is a very different question that early in pregnancy. It's a question of establishment as opposed to what ending of a pregnancy is unlawful. It's very different. So I didn't find that too helpful. So I thought to myself, okay, there are, in theory, 2 possible interpretations. The first is just miscarriage is any ending of a pregnancy. Any ending of a pregnancy in English law needs some kind of justification. And I thought, oh, that's a bit silly. So if I were to interpret this myself, I would think, okay, the ending of a pregnancy that results in fetal death must be what was meant by the provision. And when I went into it, I found that there were quite compelling arguments on the face of it as to why it could be interpreted either way. And I would argue it should be interpreted in the narrow sense, but there are arguments for both sides. So the first, so this is the broad meaning of miscarriage is all encompassing. The first reason is that it might be this broad, is that the offence is not outcome dependent at all. So other statutes that operate in this area, like the Infant Life Preservation Act, make reference to the fact that a fetus has died. The offence makes no reference to whether or not a fetus has died, and actually it's possible for it to be committed even if there is no fetus. So I thought it must be very broad then if it's not bothered about the outcome. Secondly, the Act says procuring miscarriage by any means whatsoever. By any means whatsoever could be those means that aren't intended to result in death. So the delivery of the product of pregnancy at any point would be any means whatsoever, technically speaking. It also, and this is a matter of semantics, but I thought it mattered quite a lot. English law is very clear, and has always been very clear, even in 1861, that a fetus is not a person. And this offence appears in the Offences Against the Person Act. So it occurred to me potentially that the offence isn't actually against the fetus, it's against the woman's pregnancy. So the offence is committed against her pregnancy, against her, but not against her fetus. And finally, the fact that defences in the Abortion Act were constructed in such a way that gave a doctor a defence when there was a premature delivery type situation, so when a woman was experiencing a distressing pregnancy and needed a premature delivery, was a codified defence. That in itself, to me, it made me think, why was it that the Houses of Parliament felt so inclined to create explicitly a defence for that, unless miscarriage is so broad? Reasons why it might be defined narrowly, if there were ever a dispute. The first was that in 1861 there just was no technology at all thinking about premature delivery in any kind of way. So when they're trying to legislate to criminalise abortion, they are just thinking about those circumstances where women are using herbal remedies to try and end pregnancies really early on. So that's all the Act was ever meant to do. So even if it's worded badly, if we look at the intention behind the Act, this is what it must mean. Secondly, whilst it does say in the Offence Against the Person Act, any means whatsoever, it gives some examples. So it says poison or other noxious thing or any means whatsoever. And potentially the fact that the wording has specified two, I've called them violent means, but I don't think that's quite right. It's not nice terminology, but means that would, of course, result in a fetal death. The fact that it's specified it that much, I think, does indicate a narrow interpretation. And then the two final things are, presuming this ever did come before a court of law, there are two principles of statutory interpretation that I think would weigh in quite heavily. The second one down here probably should have been first. The principle of fair warning is just a principle of statutory interpretation in criminal law. Generally speaking, if the wording of a criminal offence is ambiguous, it tends to lean towards an interpretation that assumes innocence as opposed to guilt. So in this circumstance, someone could quite naively, well, it's not even naive, is it? Someone could look at this provision and think premature delivery was irrelevant, and there would be no crime, and I think possibly that would weigh in. And that's definitely what happened in this case, which I'll come to in a minute, which was about abortion. And the second one is the principle of updating construction, which specifically relates to medical cases, and it basically says that we should interpret statutes within the best medical insight of the day's advisement. So if medical technology has moved on to such a point that the wording of something has changed, we should take that under advisement. So there's all that complicated stuff about what miscarriage even means. And then even if miscarriage does encompass these situations where you're opting for ex utero gestation and that's a criminal miscarriage, the wording of the Offences Against the Person Act still says unlawful procurement of miscarriage. So potentially the unlawful miscarriage is different from a miscarriage. So let's assume that it does include these choices to opt for ex utero gestation as criminal activity. Is it unlawful by virtue of the statute? And I think potentially not for two reasons. So the first is this Bourne case, and this is occurred in 1938 but heard in 1939, is a doctor who procured an abortion for a 14-year-old girl who was the victim of a really violent rape. And in this instance, the judge was adamant and I guess emphasised it about 4 times in his judgment that the use of the term unlawful in the Act was not meaningless. And so it was possible for judges in that instance to import a defence of effectively best clinical judgment, so acting in the interests of a woman. And in that circumstance, obviously it was deemed very important that she had access to that service. So potentially then, if in that circumstance unlawful was deemed important, so should it also in all of the circumstances I've talked about, where a woman wants to access an alternative to pregnancy and actually no bad outcome is happening for her, and if we assume it's relevant for the fetus as well. Bernard very kindly also directed me to this Canadian case, Creedy, which it's terrible. I'm not even going to try and pronounce the region where this comes from. But they held a very similar thing. So at the time, the Canadian Criminal Code was very similar in terms of wording to the Offences Against the Person Act, and the judge in this instance said that it was very obvious that not every abortion provided by a medical practitioner would be unlawful, and I would argue that the circumstances I've talked about also would not be unlawful. The only thing that I think is kind of confusing is the Abortion Act 1967 is effectively designed to be the list of defences to abortion. So effectively, the word unlawful might just mean the list of things that have been provided expressly by Parliament, or it might mean a broader common law defence, and I think there could also be some dispute about that. So in terms of impact, whilst this is obviously a very theoretical exercise, I think the definition that's afforded to miscarriage and to unlawful miscarriage is really important for 2 reasons. The first is just symbolic, right? If you say that any ending to a pregnancy needs explanation, I think that's really, it's really derogatory, right? It asks for an explanation, a stigmatising sort of effect, asking for an explanation as to why a woman might want to opt out of a pregnancy, and it just makes me a bit uncomfortable. And the second is that there could genuinely, say this technology exists, be a legal dispute about the obligation to remain pregnant and whether there's a duty to gestate naturally as opposed to by machine if there were alternatives. And I think that's a socio-political question that's probably beyond my expertise, but I don't like the idea of a duty to gestate if there's alternatives, and I think this is a route for that argument. I will be quick, I appreciate I've talked for a really long time. But for thoroughness in my paper, I still talked about the defences in the Abortion Act as the only defences available, even though I think it's probably unlikely to actually be a criminal offence after all of this stuff. Somebody asked in one of the written questions actually about how abortion is provided in England and Wales, and it is still a medical model. So even on what is frequently called by commentators the social ground, so up to 24 weeks, abortion is liberally provided because all a doctor has to say is that the risk of termination is less than the risk of remaining pregnant. And before about 20 weeks, statistically, that's usually true. Particularly if you're accessing things like drug-induced abortion. So this means that abortion is relatively accessible. But I don't think that that would necessarily be the case in terms of partial ectogenesis. So even if you could opt for partial ectogenesis before 24 weeks, I think you would have a hard time proving that opting for partial ectogenesis and that entire process was less risky than just having a normal pregnancy, unless there was something wrong. So I think that might be a difficult place to start. Also, English law is very clear, and it's been reiterated a number of times, most notably in a judgment, Burke and GMC, that patients can't demand one treatment over the other. So if I went to my doctor and said, I want my pregnancy to end, and he says, okay, you can have an abortion, I couldn't turn around and demand partial ectogenesis as an alternative if they did not offer me the alternative. So the second ground is the risk to life. So these are some of the circumstances I was talking about where there is a potentially life-threatening condition and potentially we might care about it at a lower level of risk. That sounds awful. We always care about it, but at a lower level of risk it might become relevant. English law states that the risk to life must be greater than the risk of termination. So this is still a balancing act in the law. So doctors still have to establish that the risk to life is very significant to outweigh an abortion later in gestation. This is actually a really simple defence in the kinds of instances I was talking about, like severe preeclampsia and stuff, because those things are life-threatening. What worries me, though, is I think that doctors would really struggle to form the opinion in good faith that there was a serious risk to life at lower levels of risk that mean that they could opt to end a pregnancy and opt for partial ectogenesis in some of the circumstances I was talking about, and so the ground doesn't quite cover that, I don't think. Then there's the risk of grave permanent injury. And I think it's really notable in the law that this isn't a balancing act, doesn't require doctors to assess the injury versus the risk of termination. But to me, that emphasises quite how serious the injury must be for this to be justified. And the Lord Chancellor did say as well in the Hansard debates in 1990 that it was designed to be a very stiff test. So it's not going to be the kinds of instances where there's some injury. It's got to be grave and it's got to be permanent. In the Bourne case, a woman being a physical or a mental wreck, if she didn't have access to abortion, was deemed sufficient. So maybe this is quite a broad ground, or we could construe it in that way. I have seen some quite compelling arguments by feminist philosophers that all pregnancy is very dangerous and causes serious injury and all of these very important points. But I don't think that it's likely that that could be legally entertained in this kind of scenario. Very arguable though. And then the last thing is the idea of a common law defence, so it being doctors' discretion. So the good faith defence for doctors for providing abortion has been around for a very long time. So first iterated in Bourne in 1939. I think in a circumstance where a doctor is performing partial ectogenesis at a woman's request with no intent that the fetus dies, very unlikely to be criminal activity at all. And there are lots of judgments that illustrate that judges and the law generally is actually really unwilling to intervene in intervene criminally with clinical discretion. So Patton's just one example where they said that unless there's clear bad faith and an obvious attempt to do something criminal, we're not going to say that a doctor's activity is criminal. That's effectively almost, to me, a reversal of burden of proof, right? It's not just that a doctor has to act in good faith, it's that they have to do something obviously bad. And this wouldn't satisfy that. I think there are a variety of reasons why either doctors, either doctors wouldn't be prosecuted, or where they are, a jury would be unlikely to convict. There are a string of cases in English law, like Smith, and also the Morgenthaler saga here demonstrates that there's generally an unwillingness to prosecute doctors where they think that they have done the right thing in terms of providing an ending to a pregnancy on clinical grounds to protect people. And I think that particularly where the intention is not that the fetus dies, that would be very difficult to prove that it was criminal activity. I've only put a question mark here by good outcome because I would be interested, and obviously this is all theoretical, but I would be interested as to whether people would think about this like generally people would think about it differently if there were failed attempts where things had been promised and fetuses died and women were upset, compared to if it was successful, and whether or not there might be some interesting scope for the criminal law here. I don't know whether anyone's seen Grey's Anatomy, but there's a rogue doctor going around trying to put fetuses in a bio bag, and that's kind of what I'm envisaging might become criminally relevant in some way. Even absent prosecutions, though, like I said, they're unlikely, guilty verdicts. 3 reasons why it's still a concern. The first is ambiguity in the law. I don't like it. Lots of people don't like it, including the Supreme Court. So ambiguity is generally thought of, even in the abstract, to be a violation of human rights of subjects before the law. Secondly, uncertainty does limit access to technology, and I've argued this in another paper with respect to abortion, is ambiguity in the law tends to foster moral uncertainty amongst doctors. So unless we're very clear about what this technology does and what's legal with this technology, I think it might put some doctors off using it in some instances. Again, very hypothetical and very far in the future, but I think it's important to bear in mind. And finally, medical control. So, lots of the authors I mentioned at the beginning, I think were right to talk about artificial wombs as having the potential to alleviate women of some of the burdens placed solely on them in reproduction. I don't buy the argument that artificial wombs are the solution to women's oppression, for 2 reasons. Firstly, because I think that problematizes the gestating body and claims that there is something inherently inferior about being a woman and carrying a pregnancy, when actually what's the problem is society's response to a woman's body and the fact that she's carrying a pregnancy. But I do think pregnancy is hard and really difficult, and if we can alleviate some of those burdens through technology and offer more choices, that's good for women. But this is only possible if women are able to decide which burdens and which risks they're willing to tolerate during gestation. In English law, abortion is excessively subject to medical control, which I think is a product of history in terms of the formation of the NHS and doctors being worried about losing a lot of clinical discretion around that time. But I think medical control in itself is based on unsubstantiated state interest in the fetus and an assumption that if we remove the law, all of a sudden women would be doing bad things, which is untrue, as we can see from the Canadian example. But I think having a law in place in that way is really harmful. And I would advocate for decriminalisation for that reason. And I did in that paper, but there's so much to say and so little time. So, yeah.
Well, thank you. We're indebted to Chloe for introducing a contentious topic. And I simply want to deal with the status, especially in criminal law, of the gestate. When in future years Wikipedia and dictionaries like the Oxford Dictionary trace the origin of the description gestating, I hope that Chloe's name and writing will be cited. In Canada, we don't have the concerns that still exist in other countries with criminal abortion. Following the 1988 Morgenthaler decision, the Supreme Court declared that the criminal code provisions are unconstitutional. Interestingly, Chloe mentioned the significance of the word unlawfully and the fact that the 1938 Bourne decision stated that the expression in the Offences Against the Person Act 1861 of unlawfully procuring a miscarriage is not meaningless. When that provision was first embodied in the Canadian Criminal Code, it included the wording from the English, from the United Kingdom 1861 Act. But in the 1960s, the criminal code was stripped of unnecessary expressions, and the word unlawfully was taken out, as if that simply was surplus verbiage, and the significance of that was entirely missed. The issue that we have to address is tied up very much with language. We speak of termination of pregnancy. Again, Chloe has pointed out that inducing labour, premature delivery, terminates the pregnancy. And if, as the criminal law was amended, to say that procuring a miscarriage is always unlawful, then we have some major problems with routine medical practice. Fortunately, we don't have to probe that because of the Supreme Court's decision. But we still have the problem in the historic word miscarriage. The alternative to miscarriage is carriage. That is, the woman carries the pregnancy. The issue that Chloe focuses on is whether the artificial womb also carries the pregnancy, or whether the pregnancy is terminated when the product of conception is removed from the woman. And delivery wouldn't be a normal vaginal delivery, it would have to be by caesarean section, because the way the unborn child, the child that was unborn, is connected to the placenta, has to be preserved as the child is transferred to the artificial womb, the artificial placenta. The language of the criminal code is important. I'm going to read two provisions of the criminal code. Unfortunately, I don't have them on the screen, but the wording is important. I'm simply going to read the two sections, section 223 and section 238, and then go back to try to draw out some of the implications of the wording. Section 223, subsection 1. A child becomes a human being within the meaning of this act, the criminal code, when it has completely proceeded in a living state from the body of its mother, whether or not A, it has breathed, B, it has an independent circulation, or C, the navel string is severed. Section 238 is concerned with the killing of an unborn child in the act of birth. I'll read section 238.1. Everyone who causes the death in the act of birth of any child that has not become a human being, in such a manner that, if the child were a human being, he would be guilty of murder, is guilty of an indictable offence and liable to imprisonment for life. This is obviously comparable to the punishment for homicide, for murder, the contrast being that murder has a minimum sentence of life imprisonment and different conditions of eligibility for parole release, whereas section 238 sets life imprisonment as the maximum, but there's no built-in minimum sentence. So, what is the gestate code? Is it a human being? Is it, in other terms, a person? And the personhood issue still resonates in the context of abortion. Proponents of fetal personhood are trying to introduce the rigidity of the criminal law with the prospect of criminal liability, whereas historical abortion law, accepting that there could be lawful abortion, would introduce more flexibility regarding the prospect of viability. The language, a child becomes a human being. Clearly the unborn is human, all of its tissues and organs are of human derivation. The historic criminal language spoke about a reasonable creature in being, and what the phrase "in being" has been taken to mean is functioning in society. There are Canadian judgments that are contestable, saying that the unborn child in the uterus, in utero, is simply an aspect of the woman's body, and although it's not a separate person, one could say that it has, at least genetically, an individuality different from that of the woman who bears it. We are going to use the expression ex utero as the alternative to in utero, but I'm pleased that Professor Bottoms is here, and I had the advantage of his Latin scholarship some years ago to ask if in utero is contrasted with the ex utero, and he advised me that the correct Latin is extra uterum, but the expression ex utero has passed, however ignorantly, into the literature, and I think we have to adopt it. So a child becomes a human in being within the meaning of the act, and it has completely proceeded. Now this is interesting language because recovery of the gestate claim for transfer to the artificial womb would be by a procedure, that is caesarean delivery. There would have to be preparation in order to maintain the connection and transfer the connection with the supporting placenta. So we're dealing with the human being that has completely proceeded. Interestingly, section 238, killing an unborn child, speaks about the act of birth. And of course, if the woman is naturally delivering the child, if there's a normal vaginal delivery, then the medical team is waiting for the woman to deliver. The word obstetrics is based on the Latin for standing still, standing around. Stat, I think, means being stationary. So classically, the obstetrician stands around until natural delivery. But when there is a caesarean delivery, there has to be medical preparation and medical intervention. And of course, cutting the abdomen to recover the contents of conception, the product of conception, is a surgical procedure. But what is meant by completely proceeded? We think of this in terms of the 3 dimensions of space. That is, that the fetus is outside the woman's body. But there are now means of undertaking fetal surgery in which the abdomen is opened as for caesarean delivery. The umbilical cord remains intact. There is management, manipulation, surgery on the fetus, and the fetus is then put back into the uterine cavity for the natural completion of gestation. According to section 223, what is being put back inside the woman, if we take the 3 dimensions of space, is a human being. One human being entirely encapsulated in the body of another human being. And this is something that the law has not addressed. Another way of looking at this is that the phrase completely proceeded deals not simply with the 3 dimensions of space, but with the 4th dimension, time. If the extraction is for temporary removal of the fetus for fetal surgery, then one could say that the extraction is not complete. It is simply a transitory intervention. so that what is put back into the woman's body is not a human being. A child becomes a human being within the meaning of this act when it has completely proceeded in a living state. What is meant by a living state? We know that tissues are alive. When people are diagnosed as brain dead, their organs are still alive and are valuable for harvesting for purposes of transplantation. So what are the criteria of the fetus being removed in a living state? We know that today people are diagnosed as dead, not simply through permanent cessation of cardiac activity. It's not simply that their hearts are not beating, because today hearts can be kept beating by artificial ventilation, respiration, so the breathing and oxygen in the blood would be maintained, that is, the blood system would be maintained, again, largely for the purpose of harvesting organs for transplantation. We have the concept of brain death, that is a neurological diagnosis. Well, if neurology can tell us that a person is dead, equally neurology can tell us that the person is not dead, that the person is alive. What level of brain function, what level of neurological activity in the premature fetus would constitute it being in a living state? This is something that may have to be addressed in due course. It comes from the body of its mother. This is obviously gender. We don't have some interesting questions now because we have transsexualism. We have the phenomenon of children born with ambiguous genitalia, and they can be allocated to either gender or simply have a third gender. A number of countries now have moved beyond the binary male-female distinction to accommodate third status, not Mr. or Mrs. or Ms, but as used in Germany now, MX, somewhere in between. We are going to have the phenomenon of individuals identifying as male who originally were born with female physiology. The uterus is not removed. In modern practice, if the intersex child is designated male, the female reproductive organs will be removed. But there's a strong case, and having to go into where this has been written up, that intervention should not be taken. But we're very close to having, if we don't already have, and some lurid newspaper reports in the United States indicate that we do have individuals who were born in the intersex status, who identify as male and function in society as male, but are biologically female and are capable of menstruation and gestation. And there have been unconfirmed reports that this has actually happened. So when we're speaking about the body of the mother, we may be dealing with a female gendered person who is a biologically female person who is functioning in society in male gender. If the artificial ventilator that maintains respiration is seen as maintaining the life of a not dead but living person, could the artificial womb be analogous to the mother? So could we extend the expression of the body of its mother to include the artificial womb as a substitute or a surrogate mother? And the question then is whether the gestate is still within the body of its mechanical mother. Whether it is breathed very early in gestation, lungs are solid, they're not capable of sustaining artificial, natural breathing. There's no air exchange, oxygenation comes to the bloodstream through the functioning of the placenta. But there's not a requirement in Canadian law that the child outside the mother's body is actually breathing air. It has an independent circulation. You can still be sharing this circulation with the mother. Or the navel string, the umbilical cord is severed. So we have a number of concerns with the status of the gestate king. That is, if for whatever reason the woman cannot sustain the pregnancy and the child is not independently viable, then sustaining its life through the functioning of an artificial womb is something that could be welcomed as long as the law doesn't get in the way by saying that this is a termination of pregnancy that raises some legal questions, not necessarily now under the criminal law, but questions nonetheless, and whether it is a human being, so that others, other than the mother, can assert the rights of the person. One of the arguments for designating person is that it empowers not the person who is so identified, but others to advocate on its behalf. We have examples, one recently I saw from New Zealand, where a river system was designated a person. We have arguments that primates other than humans should be considered persons. And of course, in the abortion context, we have the argument that at least the viable fetus in utero should be deemed a person. And the value of that is not that the fetus in utero is empowered, but others are empowered to advocate on its behalf. And of course, in the abortion context, that's largely to advocate against the woman in favour of continuing the life of the unborn rather than terminating it by a normal abortion procedure. So personhood is not simply a legal status, it is a form of political legal empowerment of advocacy. Let's come to the child that has not become a human being, and again, significant language. Everyone who causes the act causes the destiny, the act of birth. Again, seeing birth as natural delivery, where the woman permits the act to occur at its natural gestational stage, and then others would do with the neonate, the newborn. And this is essentially the model. The section 238, subsection 1, is followed by subsection 2, saying that the criminal penalty of up to life imprisonment does not apply if it was necessary to remove the child to save the life of the mother. This goes back to early times before caesarean deliveries would be the way of dealing with the complicated potential for birth. There have been terrible cases in which it's too late if there is a capacity for caesarean delivery is too late. The unborn child is wedged in the pelvic bones and the head has to be crushed in order to extract what now is the body to preserve the mother's life. And that is accommodated in section 238. I won't develop this further, but I simply point out that there is rich material here for further study. September in due course. Chloe, after she has achieved her doctorate and is entering academic life, with the need to draft articles for academic interest, can deal with the question, for example, of reducing multiple pregnancy by what is sometimes called a selective or fetal reduction, which we suppose in modern times means targeting an accessible fetus for discontinuation of the pregnancy so that the remainder can be gestated and delivered safely. It could be that artificial womb technology could address that as well, and perhaps in 3 or 4 years' time we'll have close literature on that.
Thank you. So I'll open it up for questions now. I have received a lot of questions from the students, so I'll take a couple of questions that I received already by email, and then we'll open it up to the audience. And maybe I'll start with the first question of Matthew Cook. Matthew, yes, was sitting in the back. So maybe his first question, because it relates a little bit to the technology and everything. Okay.
Well, let me just preface this by saying I don't really have a lot of medical knowledge, so this might just be pseudoscience, but one thing I was thinking is there a biological utility to raising the fetus in the mother's womb? And one thing in particular is, you hear that hearing the mother's voice kind of helps the baby later on. Is that something that might be lost if AWT becomes kind of commonplace for mothers?
Yeah, no, it's a good question. So there is a paper by Natasha Hammond-Browning, and she talks a lot about the idea of uterine experience, and she looks at the psychology of like what being reared in an artificial womb would be like, and advocates that it's different. I think that's important. I think it's something to weigh up in the question of a potential duty to gestate, and I think it's a socio-political question of if there are 2 alternatives and potentially a unborn child might have a better rearing experience naturally because of those sorts of things, assuming we couldn't advocate them, we couldn't accommodate them in the neonatal intensive care unit, because there are still some of those things we can do with preterm neonates, aren't there, like interacting with them and stuff. But potentially there would be a question there about where we allow women to opt for the technology and not. My personal opinion is we just allow women to opt for it, taking that into account and then being informed of that, because I think women make sensible choices. But I think it is something we'll need to learn about. And some people have argued we shouldn't even test this technology on human beings because we just do not understand the psychology of a human being that would be born without having ever been reared by another human being. It's quite an interesting concept.
Hannah Epimova. Yeah.
I'll just read my question. That's okay. In your paper, you advocate that the development of AWT ought not impact access to abortion, and you also acknowledge the implications of AWT on the increased potential for facilitating the interests of the father and other parties once the fetus is viable by virtue of technology. As AWT becomes available, do you foresee, and I think you've mentioned that you do foresee, but to what extent and what kind of socio-political tension do you foresee between women who continue to expect access to abortion during early pregnancy and other parties who advocate for the infringement of the woman's rights temporarily until the fetus is viable?
Yeah, I think it's a real problem. One of the things I'm trying to wrap my head around at the moment, I think I'm going to loop a friend in to help me and write something else about this because it's hurting my head a bit. But essentially, I think with as many claims that artificial wombs could help women, you end up with an equal number of claims that it might not. And one of the biggest concerns I have is an empowered anti-abortion movement. And as I've explained, I don't think it's an alternative, but I mean, sometimes it can be hard to advocate that in a way. If people genuinely do believe that abortion is murder, it can be hard to advocate to them why it is not an alternative if they're not buying into some of the valuable concepts that I value, like women having choice. So that's an issue. I also think there are many other issues, like, for example, what happens if there is an alternative and I choose not to opt for it and my employer wants to discriminate against me because I won't opt for it? I think those are real problems. I think there are also real problems in terms of access and ensuring that not only wealthy women can access it, and how we would look at women who choose to carry a pregnancy naturally, and whether they would be like stigmatized and treated awfully, kind of Handmaid's Tale-esque. So I think it's a really interesting point, and I think you're right, it's socio-political, which is why I'm thinking of looping in another human being to help, because it hurts my brain. Yeah.
So I had a question actually precisely on that by Emily, but so this is more or less answered, I think. And so Sarah Quayum has a somewhat related question.
Yeah, I guess my question was a bit related, but so in your paper you do, I'm sorry if I misunderstood, but you do advocate a bit about the point that AWT would provide women more rights and autonomy to their body, but how does that work if doctors still act as the gatekeeper?
Yeah, no, I think that's precisely the point that this exercise helped me to realise is the extent of medical control. Like, there are lots of commentators, quite rightly, who write amazing things, like Sally Sheldon, commentaries in English law talking about how there is so much medical control. But this exercise, I think, helped me add to that debate, I hope, in some way by looking at quite how extensive that medical control was when applied to other circumstances. So it's not just that women might have trouble accessing abortion, and it is true that it's so dependent on English law and your doctor framing your request in a particular medicalised way for you to even access the procedure. It's also about those decisions potentially later in pregnancy and how we frame those as well. Like, I already feel uncomfortable with the way that the Act is written. It requires that balance of rights between, and English law is very different to the way Bernard described Canadian law on the matter of a legal status. Shameless plug, if you have an interest in the idea of personhood, I have a paper on that and the gestating and fetal surgery and stuff already out in the medical law review, but I think it raises some complicated problems that now I've lost my train of thought, so I can't remember where I was going with that. What were we talking about? Yeah.
Jenna Carr.
So my question is actually quite off base from everything that we're talking about. But I was thinking about the wording that you were using for the reform. So you're talking about with the intent to cause fetal death. So I'm not too sure about English law, but in Canadian law, like, the intent of mens rea is very high. So I found one case where it's a person who foresees that a consequence is certain or substantially certain to result from an act, which he does to achieve some other purpose, intends that consequence. So I was thinking, why would a lower mens rea like recklessness not work? Or even alternatively for the reform, could you carve out an exception for an intent to perpetuate life or gestation ex utero? Would that accommodate the AW type?
Yeah, it's an interesting question. As I say, I would advocate first for a kind of Canadian decriminalisation, and if that doesn't work, the ideas for reform were mainly a suggestion of that's the best case scenario. If we can't have that, those kinds of ideas. We do have a similar concept in English criminal law. We call it like oblique or indirect intent. So if something is almost completely foreseeable from what you, as an end point from something you do, you would be said to have intended it. So of course, the example you mentioned would be how it would work in English law. And the question I think is important in terms of the experimental use of this technology at first. Would the first doctors who intended to use this kind of technology be easy to describe as reckless, or effectively having the oblique intent to cause fetal death when they extract something for use in an artificial womb, because there's not, well, if there's very little data that it works, and normally fetuses at a certain point don't survive, that can almost be said to be the same as an intent to cause fetal death, even if you're trying to use an artificial womb. I think it's a really interesting point. And Mel Algrani briefly mentions it in her book about regulating reproduction. It's a 2018 book actually, it's really good if you're interested.
Okay, maybe I'll take one more question by David Lemesurier.
Yeah, you've largely answered kind of what I was curious about, but really I was thinking about, I mean, you mentioned in your paper that the technology currently, they could foresee it maybe for post 23 weeks of gestation, and that maybe it could move earlier to 18 weeks of gestation. And I was just kind of curious if that technology continues to advance and the viability continues to decrease in terms of weeks, the impact that would have on access to abortion. I mean, we've talked about that quite a bit, but if there wasn't the necessity for a woman to remain pregnant for very long to reach the viability point, would it kind of empower abortion activists?
Yeah. I mean, I think it will. I definitely think it will.
Yeah.
I think what's interesting is the way that abortion is provided at the moment, the way the law is written in England. 13 weeks is about the point. The vast majority of abortions happen before then, and I don't envisage this technology for a very, very long time getting to the point where, you can use it before 13 weeks. So I think in real terms, limited impact, even if this technology starts doing this, at least for a foreseeable future. But what I have argued, and I think this is an important point, and it's a nuance, I think, that is very real in medical practice, is conscientious objection is allowed under the Abortion Act. And I think there is the potential, if you have this kind of technology, because the medical profession are so empowered anyway by the way it's written, that in combination with conscientious objection, fostering a kind of moral uncertainty amongst professionals who don't have the kind of resolve that some doctors do, could be a greater problem. And I take issue with that in a paper because I think that that's not subject to a kind of legal check. It's very hard in England for you to challenge a doctor if they don't want to provide a service to you. And it's not subject to any kind of democratic check either, because people in England, there's a bit of a political thing about staying away from abortion regulation largely, although we have just had a very amazing vote about decriminalisation in Northern Ireland. So, but as I said earlier, I don't think we'll be talking about abortion for a while, so there's other things to worry about.
Is there anyone with the last burning question? Yes, I actually, you may have sent me very early on a question, yes.
Yes, I think I did. That's okay though, I'll just read it now. And you already have spoken to it, who asked about it, but I'm curious about maybe the second half of the question. So I'll read it out, and I did ask for more patience, it's a bit long. You stated that termination use of AW should not be considered an alternative to conventional termination. Can you elaborate on that specifically? Do you think the development of AW may present women with a moral obligation to use it in all cases in the interest of preserving life? And do you think that medical practitioners may also have similar obligation? While the right to bodily autonomy is still engaged, because you mentioned the varying levels of invasiveness, I think we can agree that those rights are significantly less engaged than a typical pregnancy, and arguably way significantly less expectations are at life. So you answered all of that, I think, already. And then the second part is, do women have the right to dictate termination of life of their genetic offspring where bodily autonomy is not engaged? If not, can you speak specifically to the impact on disability rights and where women may no longer have the authority to terminate pregnancies because the fetus is afflicted with a disability, perhaps diagnosed at PGD, because it is not necessarily a woman's right to decide that a disabled life is not dignified enough to be worth living if it's not, if she's not carrying that life. And then I also had a second question that was kind of related to that. Do you know at all if the skin-to-skin contact is also engaged in the womb as endometrial contact? Or so two questions. Sorry, answer the first one first.
Okay, I'll start with the last thing because I should issue the disclaimer that I'm not a scientist. So I mean, I've read all their papers and stuff, and they're super interesting and easy to read if you're into that kind of thing. But I wouldn't be able to give you a comparative. I've argued, and I think it's probably true, that an artificial womb would be a more removed experience because you don't have the contact from neonatal intensive care or the same kind of inter-uterine stuff. Yeah. On the second point then about disability rights, if we saw me like going like this, because it's the one thing that's really hurting my head, and I just think I have no answer yet. We talked about this yesterday. I'm obviously pro decriminalisation of abortion, and I'm really pro women being able to make whatever decisions they want about whether they want to keep a pregnancy and for whatever reason. I think I become uncomfortable when we start to label that as a decision purely based on disability in that way. So the way English law is written at the moment, there is a defence for if a fetus is handicapped. And there's no definition given of handicap, and there have been some arguments in English courts about what level of severity is suitable for termination. I really don't like the symbolism attached to all abortion is wrong unless, but that fetus doesn't have a life worth living, and therefore that fetus isn't subject to the same protection. I think that has really harmful virtue signalling effects for women, for people living with certain conditions, and also for women. If you decriminalise abortion, I think you kind of almost take the tension away from that, and I think women are allowed to make that private choice if they want to. I just don't like it being publicly framed in that way. I think that's the best answer. My supervisor, if you're interested in this kind of thing, Rebecca Bennett, she's a philosopher, she writes a lot about PGD, and she's really interested in advocating for disability rights through reproductive rights. So she argues people should, for example, be able to opt for deaf embryos, which isn't strictly legal in English law, but that kind of thing.
On that important note, if you don't have any final thing to add, please join me in thanking our speakers. So I hope to see you in 2 weeks.
Sorry, can I just make a quick announcement? The note-taking service wasn't up and running yet, but there are students in this class who need a note-taker, and I think just requested probably today. If anybody wants to do that, I know our first assignment is due fairly soon, but if people are willing to be a note-taker in this class, that would be much appreciated.